I don't know if you see the presentation here.
We can see your presentation. You can start.
Thank you. Good morning, distinguished professor, esteemed members of the organizing committee. It's a great honor for me to participate in this international meeting. Of course, my name is Omar Hsiba. I'm a second-year PhD candidate in law at the Faculty of Legal, Economic, and Social Science, Suisse, Mohammed V University of Rabat, Morocco. My research focus on the intersection between economic regulation and compliance rules, exploring how these two legal mechanisms interact, overlap, and evolve within both European and Maghrebian contexts. Traditionally, economic regulation has been understood as a rigid, command-based system led by independent administrative authorities. These authorities, armed with state-delegated power, are responsible for ensuring the authorities or the market integrity and protecting the public interest. However, with the rise of large and complex enterprise operating across border, this model has faced increasing limitation. A new question then arises: how can legal system maintain effective oversight without stifling innovation and economic freedom? What drew my attention and ultimately shaped my research was the growing role of compliance rules as a more flexible and cooperative legal framework, one that complements rather than replaces traditional regulation. My research revolved around three main questions. First, what is the legal and functional relationship between traditional economic regulation and compliance rules? Two, does the emergence of compliance frameworks represent a shift away from command-based regulation? Three, and where does the modern enterprise stand today between state authorities and internal compliance mechanisms? To answer these questions, it is essential to revisit the theoretical foundation of modern economic law, as the distinguished French scholar Marianne Fraison-Roche argue regulation or régulation is no longer a purely vertical mechanism imposed by the state. It has evolved into a horizontal process, a dialogue between law, economic, and professional ethics, la déontologie. In this sense, compliance represents a continuum of regulatory thought, but with a new internal dimension. It encourages companies not only to obey the law, but to integrate legality, ethics, and responsibility into their own governance structure. We are those witness witnessing a paradigm shift in economic law from external regulation enforced by state authorities to embed compliance, a culture of internalized responsibility within enterprise. This transformation reflects the evolution of law itself from a reactive instrument to a protective tool for anticipating risks, preventing misconduct, and safeguarding systemic stability. Methodologically, this study is grounded in three complementary legal approaches. The analytical method to discuss legal concepts and clarify how compliance redefines economic regulation. The descriptive method to explain the institutional practices through which compliance operates is national and transnational context. The comparative method to contrast French and Anglo-American models, identifying points of governance and divergence in their approach to compliance. This methodological framework ensures both theoretical depth and practical insight. It allows us to understand how compliance is not a mere legal accessory, but a fundamental component in shaping responsible corporate behavior and reinforcing market trust. In a sense, it bridges legal authority with ethical self-regulation. From this comparative analysis, several findings emerge. Compliance has evolved from a corporate obligation into a genuine legal discipline. Regulation and compliance are not competing paradigms, but mutually reinforcing mechanisms. The modern enterprise become both a subject of law and an instrument of legality. In Europe, compliance is increasingly associated with the rule of law and protection of fundamental rights, particularly under the influence of EU jurisprudence such as Lever and Scherms. In France, compliance is anchored in public law, emphasizing loyalty and social responsibility. In Anglo-American systems, its focus on corporate liability and preventive enforcement. Yet both traditions converge toward what could be called a law of anticipation and legal framework designed to prevent systemic risks before they materialize. The results confirm that compliance does not signify the end of regulation, but rather its renewal. It extends the reach of law into the ethical and operational core of enterprise. Therefore, the relationship between the regulator and the enterprise is no longer defined by hierarchy but by shared responsibility in pursuit of what Frézon-Roche calls the but monumental, the monumental goals of public interest, market integrity, human dignity, and sustainable development. In conclusion, compliance law represents a new legal paradigm, one that redefines responsibility, strengthens governance, and aligns economic activity with public value. It is not a law that punishes, but rather a law that anticipates, a law that seeks legitimacy, not caution, but trust, transparency, and ethical coherence. Based on this analysis, I propose three key directions for future developments. Integrate compliance framework within national legal systems as complement, not substitute, to regulation. Foster interdisciplinary research combining law, economics, and ethics. Encourage the creation of a European model of compliance grounded in democratic value and the rule of law. Before concluding, I wish to express my heartfelt appreciation to the organizing committee for their exceptional efforts in supporting academic exchange, the panel chairs and the professor for their time and feedback, and all participants and colleagues for contributing to this dialogue on the future of economic law and compliance. Thank you all for your kind attention. I will be very pleased to take your questions and hear your perspectives. Thank you.
Okay, thank you so much, Omar Hsiba. Now the session is open for the questions. So, any questions from the members? Okay, so let me ask one question. So, Omar Hsiba, so from your findings, so of course, we can identify many social and practical implications. But I was thinking about the conceptual implications. So what do you think about conceptual implications connected to with your study outcomes?
Actually, my research revolves around three main questions. What is the legal and functional relationship between traditional economic regulation and compliance rules? And it's, as the distinguished Marianne Frison-Roche, regulation is no longer a purely vertical mechanism imposed by the state. It has evolved into a horizontal process, a dialogue between law, economics, and professional ethics.
Yes, okay. Right.
Thank you.
So, okay, thank you. So any other questions from the members? Seems no questions. Right. Okay. So then we wish to thank Omar Hsiba for sharing his interesting findings. Also,